Welcome to the Neural Implant Podcast, where we talk with the people behind the current events and breakthroughs in brain implants in an understandable way, helping bring together various fields involved in neuroprosthetics. Here is your host, Ladan Neurotech.
Hello, everyone, and welcome to the Neural Implant Podcast. So the guest today is Joe Bird of Maynard Cooper, Gale, and they are a law firm which practices in patent litigation. And today, actually, we had Joe on to talk about the Nevro versus Boston Scientific patent litigation that's going on, and this has been going on since 2015. It's pretty interesting, actually. I mean, it is a lot of legal jargon. Joe did say, like, okay, I've toned it down a little bit for you. There's a lot less of this legal jargon than there would be normally, but it can be maybe thick in the weeds sometimes. But it is very fascinating because essentially Nevro has their patents, has their claims, and then Boston Scientific is suing and saying that they're infringing on some of their patents. So very interesting stuff, and we'll talk more on the other side. Joe Bird, pleasure to have you on the show. You are actually, I think, our first legal person. I just talked to a neuroethicist yesterday, but you do something different. You're actually in a law firm and you look at the patent side of things, the legal side of things. Do you want to introduce yourself a little bit?
Sure, Ladan. Thank you. It's great to be on with you. My name is Joe Bird. I'm a registered patent attorney and a patent litigator, and my office is in Birmingham. I'm in a firm called Maynard Cooper and Gale that has offices in, besides Alabama, California, New York, and Washington, D.C.
Oh, I mean, we've met a few times basically at the Neurotech Reports conferences. And so you kind of specialize in neuroprosthetic devices, or why especially have I seen you so much, and why have we hung out so much?
Well, yeah. One thing you might not know about me is that I studied vision science at the graduate level, and that's a combination of visual neuroscience along with the other things about the visual system. And after I did that, I became very interested in neuroscience and have been very involved with learning about it, working with entrepreneurs and some in litigation for almost 20 years. I actually had a career as a trial lawyer for the first 17, 18 years of my practice. I did some intellectual property work, tried some cases involving trademarks and trade secrets and restrictive covenants that relate to IP, but I became a patent lawyer 20 years ago or so. And since then, I focused not only on patent prosecution and litigation, but also I've been part of national counsel teams for some major pharmaceutical companies in cases involving alleged neuropsychological injuries. So I really hang out in the IP space and then have a certain part of that time involved in things involved with the nervous system.
Very cool. I think it's kind of a niche thing, so not too many law firms do that. But your Maynard Cooper and Gale doesn't necessarily focus on this. It's more your personal specialty then, right?
Right. I work with some people. We have about 300 lawyers in all these different offices. And so it's a major law firm with a lot of different capabilities.
Okay. Very cool. So you wanted to talk today about kind of some patent litigation that's going on with some of the big companies in the neurostimulation space. And I find this very, very fascinating. So do you want to do an introduction on that?
Yes. So what's been interesting about the neurotech space is that it's a relatively new industry, as you know. Although products have been cleared by the FDA for over 20 years in some cases, I would say that the revenues in the industry haven't been such that it would support a lot of patent-related litigation. Patent litigation is extremely expensive. It can take literally millions of dollars to try a single case. And so what I thought was really interesting is that, and I just learned this 2 or 3 months ago, that patent litigation has been going on in the neurotech industry in a sort of a very big way now for 2 or 3 years. And it was instigated between Nevro and Boston Scientific over the spinal cord stimulator. And that led me to think that this is something that the neurotech industry might really have a lot of interest in, because there's some patent law things which we can cover. There are also some industry things that we could talk about also. I'm not the industry expert, but I certainly can talk about the patent issues and alert your listeners to some of the industry-related issues.
Yeah, I think that'd be great. I mean, not everybody's in industry. A lot of people are in academia, but I think this affects everybody. I mean, it affects funding. It affects, basically what kind of potential there is outside of academia as well. Have it not only be a scholastic endeavor, this neural implants, but actually have business side of things. And so that's why I think this patent litigation, that's why I think all this is so important, because it literally trickles down to everything that we do. So do you kind of want to describe, lay down the background of what Nevro and Boston Scientific are fighting about?
Yes. In May 2015, Nevro received its first FDA clearance to market in the U.S. a high-frequency spinal cord implant system. The high frequency means that it operates at 10 kilohertz. And, just use that as a kind of a rule of thumb. There's some variations in that, but just for purposes of this discussion, let's just say 10 kilohertz. And within a week after Nevro's product was cleared for sale in the U.S., Boston Scientific, which is clearly one of the leaders, if not the leader in this space in spinal cord implants, filed some administrative proceedings in the patent office to have some of Nevro's patents declared invalid. And that was in what some of your listeners might have heard of. The proceeding was called an inter partes review, or IPR for short. And IPRs are known to be patent killers. After a patent is issued by a single or maybe two examiners, it goes out into the public domain. It can still then be challenged in court, and most patents that are worthwhile in major industries often get challenged. And it's only after the litigation has terminated that one can really say, yeah, that patent is valid or not, because many, many patents get issued, but a fair number of those are not valid. So I think it's important for people in the industry to know some basics about medical device patents. And this relates specifically in the neurotech space. I think if I were in this business, making and developing these products and selling them, there's some things from the Nevro litigation that I think would be very helpful to know.
Yeah, and I've actually just looked up the market caps, the valuations of both of these companies. So Nevro is about 1.89 billion and Boston Scientific is 51.4. So Boston Scientific is 30 times bigger than Nevro and challenging this. So do you want to talk about a little bit about this? I mean, this high frequency stuff, I mean, you were talking about 10 kilohertz, like how close to 10 kilohertz does it has to be? Do you want to go into this a little bit more?
Okay, so first off, there are well over 100 U.S. patents that Nevro has obtained in the last roughly 10 years. And I can only speak about them. I've looked at 8 or 10 of them as I wrote some things up for this discussion. So what I'm saying is generic, and it may not apply to all of their patents, but pretty much all the ones that I've seen, all the ones that have been in litigation at least, involve claims that the range for stimulation frequency, that is, number of cycles per second or hertz, is between 1.5 kilohertz up to 100 kilohertz. And from some things in some of the litigation papers that I've seen, it appears that, and I'm not an expert on spinal cord stimulation at all, but it appears that devices cleared for marketing in the U.S. before Nevro's patents were, say, less than 100 hertz. So at least one order of magnitude less than the lowest range that Nevro claims. But Nevro apparently markets its device, its typical device, to operate at about 10 kilohertz.
Interesting. So I guess what are they fighting about? Like, does Boston Scientific claim that Nevro took this technology? Because I mean, at the base of it, honestly, it's kind of just wires with different frequencies of electricity stimulating and shocking the body into being healthy, right? So it's actually kind of a basic technology a little bit. So what exactly are they fighting about?
Well, first off, Boston Scientific is one of the leaders in this field. Apparently took it rather badly when Nevro's product was cleared by the FDA. And so they immediately challenged the validity of one patent, I guess what you would call one of Nevro's main patents. And they did it on the basis of pre-existing prior art. And so I guess everybody who does any work with devices, any sort of development of products would know most likely that one of the major hurdles to get over in getting a patent is to get around any prior art. And so that is a truly very crucial thing to do when you get a patent and when you go through litigation. The administrative proceedings that Boston Scientific pursued in the IPR setting in the PTO, each was unsuccessful. And it doesn't mean that Boston can't renew those kinds of efforts, and they probably will, but it does mean that just for right now, Boston's efforts to use prior art to invalidate these patents has been unsuccessful. Now, after these Boston efforts were unsuccessful, within a little less than a year, Nevro then sued Boston Scientific in federal court in San Francisco for patent infringement. And that's where it's gotten very interesting and very involved. And I think it's worth discussing what's happened in the San Francisco litigation, which has not yet been resolved, but has gone through the trial court and is now on appeal in Washington in the Federal Circuit Court of Appeals. So besides prior art, Ladan, one of the other major hurdles to get over to enforce a patent is the requirement of the court determining what the patent claims mean. And are you familiar with what patent claims are?
Yeah, it's basically whatever company or person claims, and it should be as broad as you can make it, but as narrow as you can also, because if it's too broad, that's bad, but if it's too narrow, that's bad as well.
That's right. Well, really, ideally, what you want are some very broad claims and a bunch of very narrow claims also, so you can hedge your bets. What a patent claim is, think of it in buying real estate. When you get a deed, the legal description is what you get. You get land that starts at this point and goes to that point and, makes and circles back around. And patent claims are very much the legal description of what the patent holder owns. Now, the patent itself may be 10, 20, 30 pages, but the patent claims are typically 1 or 2 pages. And they're written in a very stylistically unusual way, which only patent lawyers are trained to read and interpret with all the legal issues. Now, I'm not saying a non-patent lawyer can't read them and understand something, but they're written according to some many, many different rules. And so one of the rules is that the patent claim itself cannot be indefinite. It just can't have holes in it where the meaning isn't clear. And that's really where it comes down to in this litigation right now. Boston Scientific was successful in San Francisco in getting the trial court to hold that in at least a couple of ways that the Nevro patent claims were, quote, indefinite. Close quote. Now, this can't be overemphasized in terms of the importance of the wording and the exact and proper meanings of words. And this is called claim construction. Claim construction is very important in terms of getting a patent issued. Ladan, have you ever been through a patent application process?
I filed a provisional patent, so it's just like a 1-page, really fast thing. But no, beyond that, I haven't done that. I hope to one day have a few patents under my belt, but no, not yet.
Okay, so the provisional does not require any prosecution. It's there. It's a placeholder getting your priority date in case you want to file a full patent application within 1 year. But the process of applying for what's called a non-provisional patent application means that you go through a lot of wording to get the claims right, and then you deal with a patent examiner, address any of her concerns, and ultimately, if everything goes well, you come out with a patent that your client thinks is helpful and worthwhile. Now, so claims construction, claim interpretation, claim drafting is very important for that process. But a patent does not enforce itself. The only way you can enforce a patent is with a small army of lawyers. Or maybe terrorists, or whatever you call it, okay? And so in the patent litigation process, which is the only way to enforce a patent, the meaning of the patent claims is gone through with a very big magnifying glass. And so all of the words of patent claims are put under a microscope and examined very carefully. And if the party that's being sued finds any sort of ambiguity, then that party can say the claim is invalid because it's indefinite. And that's in fact what Boston Scientific did. And it's probably good to just go ahead and talk about what. Then there were several areas of alleged indefiniteness, but there are two that really are, I think, very interesting. Now, before we get to that, let's talk about what the patent claim in the Nevro litigation really is all about and what it says. I'm not going to read it word for word, but this is a representative claim that was actually litigated in the Nevro case. So this claim is there are probably thousands of claims in all the Nevro patents, but this is one that was singled out. So the claim says a spinal cord stimulation system for reducing or eliminating pain in a patient, the system comprising an implantable signal generator configured to generate a non-paresthesia producing therapy signal, wherein at least a portion of the therapy signal is at a frequency of 10 kilohertz and at a current amplitude, and a current amplitude range from 0.1 milliamps to 20 milliamps. Okay, so there's a little bit more to it, but that's the main part of it. So coming out of the San Francisco trial court, there was an order the trial court entered saying that there were at least two ways what I just read is indefinite. And this is what I think even a non-patent lawyer would have interest in. So do you have any questions or should I add anything there?
I guess this kind of goes with my comment, like this seems exceptionally broad.
Yeah, and especially given the fact that spinal cord stimulators have been on the market for at least 20 years, there's a lot of potential for overlap. So let's just talk about two very specific problems that the trial court found with this kind of patent claim. The one is the phrase, an implantable signal generator configured to generate a signal. Now, the phrase configured to generate is exactly what the trial court focused on. And what the trial court said was that it could have two meanings, and that is this. It could either mean the device, the spinal cord stimulator, has the capacity to generate a proper signal without any further programming at the clinical stage. In other words, it comes from the factory without having to be reconfigured, reprogrammed. Or, separately, that's when it leaves the factory. Or the trial court found that it might be that it's programmed or changed at the time of implantation by the clinical programmer to generate the necessary signal. So what the court said was that there was ambiguity whether the product left the factory able to generate the proper signal or whether it had to be programmed in the doctor's office, in the operating room, to generate the signal necessary to provide therapeutic relief. And there's a lot that has been litigated and said about this issue between those two parties, and I haven't been privy to all that. But it's pretty clear that at least the trial court thought the wording of the patent claim did not state very clearly when the configuration to generate the proper signal occurred. Now, there's a lot of law here in the field. As you can imagine, I think Nevro even submitted evidence that something like 40% of the last million patents issued have used the term configured to do a certain thing. And I cannot speak to the merits of this. I can say that through the trial court proceeding, the trial court at least felt like it wasn't clear exactly when the product fulfilled all of the patent claims. And the idea here is that patents need to be clear so that people who see the patent understand how to avoid infringing it. And that's a very important concept for patent law. Now, the second major area of alleged indefiniteness was the phrase, let me just go back to the operative language in the claim. So the first element was an implantable signal generator configured to generate. Okay, then the second aspect that I'm now talking about is to generate a non-paresthesia producing therapy signal, that is, without causing paresthesia or the tingles or other sensory perceptions of the stimulation waves themselves. All right, so are you with me on that?
Yeah, that makes sense.
All right, so this is a really important subject for patent law, and that is, can you patent something that doesn't create an effect? So normally, the traditional sort of approach to a patent is to say, list the elements of the patent, and then you say at the end, so that X, Y, and Z occur. But it's pretty clear that one of the most important aspects of what Nevro's high-frequency 10 kilohertz device does, or is what it doesn't do, and that is it does not apparently create paresthesia feelings. And why that is beyond the scope of this discussion. And I'm not even sure if anybody really understands all the basic aspects to the mechanism. But the lack of paresthesia, the tingles, and some unpleasantness in the sensory area is a significant part of the Nevro product's effect.
I don't actually understand why that would be such a big issue, because they do want to cause an effect, but don't want to have a side effect. So basically it'd be like, okay, this is a chainsaw that we have that doesn't kill you, something like that. I don't know. I think those two things are linked. It's not just like, oh, this object doesn't kill you, something like that.
Well, let me put it this way. The two things that are tried and true in the area of getting a patent claim issued are to say that it has a certain structure or a certain composition. If you were to just say the chainsaw, you were to describe it in a patent claim, it has a motor, it has gears, it has a sharpened chain that revolves around an oblong, stiff metal structure. And that would be a description of the structure. Or you could say it in terms of what it does. The engine turns rapidly, and it also then turns the chain rapidly around the oblong structure. So those two ways of approaching a patent claim would be either what it's made of, how it's actually built, or how it actually works, the process by which it works. Here, what the trial court did not like about Nevro's claim is that the paresthesia is not a property of the signal itself, right? It's what they would call an effect of the signal. So you with me? In other words, you can't look anywhere or see non-paresthesia in the device itself. It's the effect. It's the claimed effect of the device. It's not the device itself.
Okay, yeah, that does make more sense.
So taking that a step further, the court said that circumstances for different patients can be different, so that it wouldn't actually be possible to know the effect on a patient without seeing the patient, him or herself, right? So what the trial court is really saying is it's the non-paresthesia producing language of the claim is subject to each particular person's reaction to it. Now, I also think this is pretty interesting for industry people to think about. There are essentially two kinds of patent claims. One is, and it's what I really just referred to, there's the article of composition or the structure of a device or any kind of chemical formula or anything. You recite the structure. That's called a device claim or an article of composition. The other kind of claim is for a method. You do step one, then you do step two, and so on down the line. The trial court, in finding that non-paresthesia producing was indefinite for the device claims, however, found that the same phrase was not indefinite in the method claims. And there are a number of method claims. And the reason the court said that is because the programmer, the doctor, physician's assistant, whoever, is there on the spot with the device implanted, trying to determine what the correct signal parameters are for each particular patient who's received an implant. That person would be able to tell whether there was a paresthesia or not. And the method claim is not dependent on the structure itself. The method claim relates to the steps you go about to achieve a certain result.
Almost a calibration by the user or by a technician, something like that, right?
Exactly. So the same phrase, non-paresthesia producing signal, is considered indefinite by the trial court for the structure of the device, but is not held to be indefinite for the many method claims that exist in the Nevro patents. Now, a further thing that needs to be said, though, about device and method claims is that the strategy to enforce a claim relating to the structure is different and probably easier than it is for enforcing a method claim, because the structure claim, the device claim itself, it's determined when it leaves the factory. It's determined by the hardware and the firmware and whatever all the programming capabilities of the device are. And that's going to be the same for every device that's made in the same product line. But a method claim is harder to enforce because it depends on what, as you say, the calibration is in the clinic itself. And those kinds of steps can be different. I don't think any patent litigator would not prefer a good structure claim to a good method claim when you're talking about a medical procedure or a medical device. In other words, there are fewer issues about what is standard and what's abnormal in enforcing a claim about a device compared to enforcing a claim for a method, because the method depends on what's done to each patient. And so this has a lot of implications for Nevro's patent strategy. Case is currently pending on appeal. There are some other issues pending, but I really focused on these because I thought this would actually give non-lawyers a better understanding of how they need to interface with their patent lawyer. And I think there are a few takeaways that I would probably want to have people think about. The first is, of course, the patent lawyer has to draft the application and finalize it, but the inventors and all the company representatives associated with that process need to provide as much specific information about the timing and circumstances for every step and method involved in using a device. You need to be completely transparent about everything. I will say, as somebody who actually prosecutes patents, some patent clients don't want to tell everything, because if the patent is invalid or after it, if it's rejected or if it gets set aside or whatever, they don't want to tell everything about how they do what they do, right? You'd be surprised how much about products that are patented doesn't go into the patent itself. It's a natural tension. There's a natural desire for anybody who gets a patent to try to hold back some aspects of what the device is. Now, you can't hold back anything that is truly important to the description of the patented invention. But there is a tension there, and people do sometimes, and I've seen them do it in litigation. I've seen people that actually refuse to disclose everything to the patent office that they needed to, and their patents have been held invalid. So that's important. You've got to tell everything you can about all the patented aspects of the invention. You need to also, and you alluded to this a minute ago about broad versus narrow. You need as many different kinds of patent claims as you can possibly get. And in the case of Nevro, I think they've probably had 30 or 40 patents issued from the same initial patent application. And you think about that. I mean, they probably got 500 to 1,000 patent claims from a single patent application. They've done it in a number of different patents. They've had what I would consider a pretty good strategy of being overly inclusive about every different operating parameter. And look, I don't know their patents well enough to know whether they really have dealt with these questions of indefiniteness. But it's just a good reminder that every word you say in a patent claim needs to be fully supported and tied to something that's actually occurring in the real world.
So are you saying that they protected that original, they fortified that original patent with 40 other ones? Like, that's actually what I was going to ask. Like, how can you have 100 patents? I mean, it would just be kind of like, it'd be very, very overlapping, right?
Yeah, you can't have the same patent issued twice. So somebody at the patent office, every time they issue a Nevro patent, has made a determination that there's not that overlap. And that's called double patenting. And so I would think, from looking at the 8 or 10 Nevro patents that I've seen from this litigation, that slight changes in the wording, slight changes in the parameters and the frequency, the amplitude, the pulse width, that's the reason that all these different patents have issued. What they probably decided was to go after, in the initial patents, the parameters that they thought were the most important. But then as they kept learning about the device after it was on the market or after it was going through FDA trials, they probably learned new ways that they could describe something about the device. Now, it all had to be included in the original patent application, but it apparently was a very big, lengthy application they filed 10 years ago.
Wow, that's pretty incredible. Okay, so what does this all mean for, I guess, the general neural implant community? Like, what can we learn? How will this Nevro versus Boston Scientific patent litigation battle affect us?
It means that the more money a product generates, the more likely it will end up in patent litigation. So if you have a product that is, say, just been cleared or is about to be cleared, if it's a new product, completely new, nobody else is doing this particular thing, you're probably safe, because only people with a lot of money, or that, now there are some plaintiffs' lawyers who do patent work on a contingency basis, but that's not very common. So I think the more successful your product is, the more likely you need to be aware of the potential for patent litigation. And then I would say the second thing that is, I think, very important for the spinal cord stimulator community is that this litigation is probably going to go on, I would think, for several more years, because only 10 or 12, maybe 8 to 12 of the patents of Nevro have actually been through any kind of litigation at all. And they have more than 100. They probably have a dozen or 2 dozen more left to be issued, and they're probably filing new ones all the time. So I don't think the war over high-frequency spinal cord stimulation, I think the war has only begun. So if you're in spinal cord stimulation, you need to be aware that this could be a very costly part of the environment for entering the market.
And would the companies be able to do business until that time, or would they be blocked from selling this device?
Anybody that gets sued for patent infringement can continue to market their device until a final judgment, unless a preliminary injunction is issued. And a preliminary injunction is harder to get, but it can be issued before the final outcome of the patent litigation.
Wow.
I will say this too, and this is a new development, and it's actually the reason I learned about the Boston Scientific Nevro litigation, and that's because StimWave was just sued by Nevro also. And StimWave now that litigation was filed in February 2019, about 2 months ago. And it hasn't gotten very far at all. There's very little that's been made public. And Nevro has filed an answer and denied any wrongdoing, just as Boston Scientific did. And so there's really nothing that any of us can say about who's likely to win. It takes a tremendous amount of factual background to make any comment at all about who is likely to prevail in any of this. It's just that with the filing of the Nevro case against StimWave, it's clear that Nevro is probably going to spend whatever amount of money it takes to keep everybody they can out of the high frequency market. And I would guess that the high frequency range is a very good range in terms of what patients and doctors think is helpful. So I think what you're going to see, I think some spinal cord implants with other companies are under development. And so it sounds like in the spinal cord implant area, because it's probably the largest category in terms of neuromodulation products, in terms of revenues generated, that anybody who gets into the spinal cord implant market needs to be highly aware that patent litigation could be coming if you don't watch what you're doing.
Yeah, really. And then you get the company coffers get drained, and the only people who get rich are the patent lawyers like yourself. So actually, have you picked out a second yacht yet?
I'm actually still working on the first, but you know what? When I get it, Ladan, you can come visit.
Sounds good. I'll do that.
I'll just say that patents can be enormously valuable, but the most valuable patents take a lot of money to obtain and to protect. And it's like everything else in the world that I've discovered in almost 40 years of being a lawyer. You just sort of follow the money, and you can tell where the controversies are going to be.
Anything worth value is going to be expensive as well, right?
And highly fought over. So this is really not any different than anything else in the world. The more revenues start going in a particular area of neuromodulation products, the more a company needs to have some counsel and advice about either their patent strategy or their strategy to avoid other people's patents. That doesn't have to be a super expensive thing, but it is. I will say that if you're getting into an area that's already you're not the first person in that particular market, it would behoove you to have some counsel from experienced patent litigators about whether you could do things to lessen your patent infringement liability down the road.
Wow. Yeah, definitely. And you were saying earlier that actually the cost to issue the patent might be bigger if it's in a disputed area as well. I mean, I thought the patents were kind of standard. I mean, like kind of around the $10,000 to $20,000 price range. But you're saying the more disputed patents might be more valuable, actually, or like cost even more?
Well, so think about it this way. So in May 2009, Nevro filed 2 provisional applications that have led to, now I haven't counted, but I'm guessing 30 different U.S. patent applications. Think of that. 30 different issued patents coming out of the same application. And it might be 20, it might be 40. I'm not sure the exact number, but think about how much work it took to get that initial patent application file that would support, say, 20 to 40 issued patents. So you're talking about hundreds of pages. And, a lot of the patents you look at may be 10 to 20 pages as published by the U.S. Patent Office. I haven't looked at the provisional patent applications or the first full non-provisional application filed by Nevro, but I'm thinking it's several hundred pages.
Jeez. Wow. So that could be literally like $500,000 or something like that to file that kind of thing. I mean, if you had to guess, what would you guess?
I think if you were today filing an application for a medical device that would spawn 30 different issued patents, I'd say several $100,000.
Wow. That's crazy.
And that might take a year to get all that done. But for a very broad patent strategy with a lot of different patent claims and a lot of different patents, you're talking probably hundreds of thousands of dollars.
Wow. Crazy stuff. This sounds like it really makes only one type of person happy, and that's the lawyers. I mean, literally billions of dollars are at stake for these companies. So they want to definitely hammer it out and make sure that they're okay.
Let me just say this about that, because I know that patent lawyers and litigators do get paid for all this, but all the dealings that I've had with investors, VCs, and not only this, but other industries, tells me that the amount of investment in this industry would not occur without patent protection, because as we've seen from what Boston and Nevro and StemWave have been fighting over now, investors don't want to put money into a company unless they feel like the products of the company can be protected. So there's a fine balance between enough investment and enough freedom so that people can actually operate in a free society and free economy. So there's a balance there. And I think it probably teeters back and forth, but there's definitely countervailing factors that go in. You need investment, and you need freedom, and you need protection, and you need the ability to do something new. So it's, I don't think the balance is ever exactly right. I just think it kind of ebbs and flows. About 6 years ago, there was a major change to the patent law in 2013 called the America Invents Act. And what had been happening for maybe 15 to 20 years is a lot of things had been patented that really didn't need to be patented. There were many, many different patents on essentially software or e-commerce patents. And what happened was have you ever heard the term patent troll?
Yeah.
Yeah, so patent trolls is a nickname for really what's called a non-practicing entity. And there are good non-practicing entities such as research institutions. And then there are other kinds of non-practicing entities that don't do anything. All they do is acquire patents and sue people. And so in 2013, when we first started talking, I referred to this inter partes review, IPR process. And that's gone a long way in weeding out patents that never should have been issued. And it's a relatively inexpensive way to do it in a narrow, focused way. Still can cost several $100,000, but it doesn't cost millions of dollars that I'm sure any major patent litigation costs. So I think the Congress and the PTO are constantly trying to refine how to strike the right balance.
Wow, that's pretty incredible. Yeah, this is a very fascinating topic. I mean, I find this very interesting. I mean, hopefully the listeners do as well. Do you have any final thoughts that you want to close off with?
Just be kind to your patent lawyer.
Tip them well. They're very poor.
That's right. They need that first yacht.
For sure. Okay, thank you much. Mr. Bird, Joe Bird.
Ladan, thank you. It's always great to talk to you.
Hey guys, hopefully you enjoyed it. Actually, that did go a little bit longer in the real version, and I have cut it down a little bit. It was originally 56 minutes, so hopefully we'll get it down to like 35, 40, something like this. But it was interesting nonetheless. I love this kind of stuff. I mean, I wouldn't want to work in this field, I guess, but it is interesting to listen about it, hear about it, and learn about it, because it is a very, very vital part of this field of the neural implant community. Because even if you are in academia, even if you are pipetting in a lab somewhere, this is something that will affect you. As I mentioned in the episode, this will affect you because it has downstream effects, because these are such huge companies and such huge positions that you can go that it will affect somebody or it will affect, honestly, the funding that the professors get, PIs get. So yeah, it really affects everybody as well. So if there is a bad decision, quote unquote, then that could be very bad for the many thousands of people that are in this field and hopefully listen to this podcast as well. So hopefully you enjoyed that. I really liked it. I think I'm going to have Joe Bird on later on as well. He's working on something really cool. So in a few months, he might be releasing that. We might talk about that again. But yeah, let me know what you think. If you like this, I guess, legal stuff, I think this is the first time I've had a lawyer on the show. So I'm breaking new boundaries in this way, but I think we need more of it. Fortunately or unfortunately. Okay, see you next time.
Hope you enjoyed the show and were able to learn something new, bringing together different fields in novel ways. Until next time on the Neural Implant Podcast.